Today's episode is brought to you by DeSanto Propane. DeSanto Propane is 4 generations strong as a trustworthy family-owned business with unmatched customer service. Go online at DeSantoPropane.com for more info or call toll-free at 1-800-752-4574. Since 1937, the difference has been DeSanto Propane. Today we continue our series previewing local elections across the region by catching up with one of the candidates running for Seneca County District Attorney. Mark Sinkiewicz joins me in studio. Mark, thanks so much for being here today.
Thanks for having me, Josh.
Incumbent District Attorney, why are you running for another term?
First of all, first and foremost, it's the best job in the world. You know, when you're in the legal profession, if you're doing anything else, you have a duty to your client, your specific client, and you have to represent that client's interests. Our job as district attorneys across the state, simply put, is to do justice and to do whatever it takes to facilitate that justice. So along with that, we get a lot of freedom. We get to review cases and decide if cases should be charged or not. And then if cases are charged, we can decide if they should be prosecuted or not. And then if we decide that they should be prosecuted, we decide what sort of punishment is in order. And we're the only ones that are allowed to do that. Defense attorneys have to serve the interests of their clients and represent them. Judges have to make sure that we're following the rules and that the court system is being supported, but not us. We do justice. And so it's the best job. Now, having said that, I've been doing it for 20 years. So I feel like my skill set is of value to the citizens of Seneca County. And I want to put that skill set to use again for another term.
When you think about the first 4 years as DA, what stands out to you? What are like the kind of like banner moments, I guess, in those 4 years that feel like you look back at it and you're really proud of them, or you feel like they were major accomplishments?
So I took office in January of 2020. On St. Patrick's Day of that year, I collected my staff, brought them into a conference room and said, guys, there's this thing called COVID. We're going home. I don't know what's going to happen, but I'll be in touch with you and we'll get through this and we'll get through it together. And so then we had to deal with the pandemic, and it was remote appearances and electronic discovery and electronic filings and social distancing and having to appear in front of a grand jury wearing a mask that makes your voice sound funny and if it can even be heard at all. So we navigated through that. Sadly, I actually lost an employee to COVID, which was a very hard thing for the office. So we dealt with that. And then bail reform and discovery reform hit. And so then it was like, okay, now we have a new crisis. At one point, one of my friends said, geez, I'm starting to think like you broke a mirror before you got reelected because all this stuff is coming down. So I think when I look back, it was being at the right place at the right time, because I think I was able to navigate those successfully and get us into a position where now we're starting to normalize.
Yeah. Is from a functionality standpoint, is the COVID stuff like over? Is it mostly back to the way it was court-wise, like working the way it worked before?
It is, but there is a backlog because there were cases in the pike that couldn't be heard. So yeah. There is a bit of a backlog, but we're getting through it. So. Yeah.
When you talk to voters, what are the biggest issues that they're concerned about when it comes to a race like DA, which is so different than most other elections that people are familiar with?
It's tough because, you know, when you're a representative, you could walk up to a citizen and say, what do you want me to do? You know, and they could say, well, I want you to reduce taxes or I want you to do this. I can't walk up to somebody and say, you want me to stop prosecuting DWIs or you want me to do this? Because yeah. I have to do what I have to do. But it's always useful to talk to people to see what's on their mind. And I'd have to say that it depends on the group that I'm talking to. You know, if I'm at a scope meeting speaking before folks who are concerned about the Second Amendment, it's important to know that that's important to them. And I want them to know that I take an oath of office to preserve, protect, and defend the Constitution of the state of New York and of the United States. And that amendment is part of that Constitution. So I have to do that, and I will do that. When I talk to just rank and file citizens, a lot of questions around the bail reform. You know, why did they do that? What was the purpose of all of that? So that's somewhat of a concern. I also hear from people who are a little bit frustrated with, you know, when you get a traffic ticket, how much time it takes out of your life to try to resolve that traffic ticket. Justice courts are opened at different times of the day, different days of the week, and trying to get in touch with them is kind of difficult sometimes. And so I'm listening to all of that and mulling over ways to try to maybe expedite that for them and make that a little bit easier. So those would be kind of the main concerns at this point.
A complete aside, is it a little mind-boggling, I guess? You're in the legal system. Is it a little mind-boggling that things like traffic tickets aren't kind of like worked through a system that's more automated or digitized than
that's what
it
we
is
hear
currently?
all the time. People are like, I can't believe I have to actually mail this. You know, it's like, this is, you know, we're in the new age. And that is a frustration. We've taken some steps to correct that a little bit. We do have a way to email the applications, but it still is, you know, getting the pieces of paper and submitting them and the support documents. It takes a lot of time.
How much of that is just fulfilling requirement that the state has?
Almost 99% of it,
How do you, this is one of the questions we get all the time, because I think it's something that people don't fully understand. They don't see the DA, they don't go to court, they don't see you prosecute, right? So like, what's your philosophy and how you approach the job of prosecuting? Because you're dealing with, like you said, you know, 1 hour you're looking at traffic tickets, the next hour it could be a murder case, or so, it could literally be anything. So like, how do you approach, what's your philosophy to prosecution?
You kind of hit the nail on the head. Whether it's a traffic ticket or a murder case, my philosophy with my staff is to treat every case the same, to do the same, because that protects us from allegations of favoritism or doing something for somebody that you wouldn't do for somebody else. So that has always been my philosophy. And when we get a tough case where maybe there's a lot of public outcry or we get letters from people urging us to take a certain course of action in a case, sit my staff down and say, what would we do in any other case of this nature? That's what we do now, because if we're consistent, then we can stand behind that and we can sleep at night because we've done our job and we've done it consistently. So that's the first premise. Yeah. The second premise is we do justice. So sometimes it means that we don't charge people. Sometimes it means that we may lose a case. Sometimes it means that we may dismiss a case on our own. But as long as justice is done, that I think is the most important thing. And, we prosecutors across the state, we say that our worst nightmare is convicting an innocent person. And so to protect against that, you develop consistency in your reviews and how you approach a case, and then that protects against that.
You mentioned fairness, treating everybody the same. That question, I think, comes up quite a bit. What does fairness mean to you in terms of how you prosecute? Like, for someone who's not exposed to the legal system, how do you explain that to them, that your approach is fair, and what does that mean to you when someone asks you, are you fair?
So I guess first and foremost, I like to say that I treat everybody with respect, whether you're on my side of the table or you're on the other side of the courtroom. I hope that you feel that I've at least treated you with respect. Secondly, I think that it's important to develop sort of a philosophy of reviewing a case so that you take into account as many things as you possibly can, which might contribute to the outcome of that case. So you look at the facts, you look at what the nature of the crime is, you look to see how much damage that crime has done, you look to see the background of the defendant, what is his criminal history, what are his prospects for being a decent member of the community. Ultimately, my goal would be to restore people so that they're prosperous, contributing members of the community. When that fails, then I have to protect the community from the person, and that's where incarceration comes in. So the fairness comes into that with that review, so that we look at all aspects of the case and then decide the course of action that's most appropriate, so that justice is done, essentially.
A lot of folks will say a DA's job is to be an advocate for victims. How do you approach that, and what are your thoughts on that in terms of how you're doing your job? Because I would imagine a lot of your job does involve the victims of crime.
And absolutely, that's a primary goal, is to consider the victim, make sure that we try to restore them. The sad reality of the job, though, is that you never make anybody whole. If you've ever been a victim of a crime, you never get over that. I mean, no matter what you do. So you can't restore somebody to where they were before the crime was committed, but you can at least hope that you can restore some of the pain that the criminal inflicted, which might mean making sure that the person gets restitution, or might mean making sure that the person has an order of protection in place to protect them from further conduct. Now, we've taken that so seriously that I've been able to secure an $80,000 grant to have a person specifically designated in my office as a victim advocate. And so each morning when she arrives, she goes through the cases to see where we have new cases involving victims. She'll reach out on a personal level to those victims to make sure they know who she is and what she's there for. At each stage of the proceeding, she's there to notify the person, this is what's going to happen. You can come or you don't have to. This is what will happen. When the proceeding is over, she'll call them back and say, this is what took place. When there's information that's needed from the victim, she'll reach out to them and talk to them about it. She's present in our trial preparation conferences to make sure that if the individual gets uncomfortable, she's there to support them, see to their needs. She drives them if they need a ride to get here. She'll hook them up with community services if they need alternative housing. So we take it real serious. It's a very important aspect of our job. And again, the goal is to try to not make them 100% whole, but at least get them back to a point where they might have been close to before the crime was committed. In addition to that, we also employ Teddy, our therapy dog, who's there especially for children who are victims of crime. They are often terrified at the thought of having to testify. So we have Teddy come to the office and, giving him a few pets and having him sit and breathe on you for a little bit makes you a little bit more relaxed. So that kind of helps in the process too. And actually, it's not limited to children. We've had adults who have said, yeah, it might make me feel a little better to have them there. So we do that as well.
You say part of that at least is paid for by a grant. How important is that, given the fact that you're not a large staff of prosecutors? Realistically, how much time would there even be for, those of you who are prosecuting these cases to be able to tend to all of those needs? Would that even be something that could be facilitated, if not for that person or those persons who are dedicated to it?
I'm fortunate to have been there long enough to know the answer to that, because there was a time in the past where the person who handled victims was a part-time person who did so many other things. And if you could catch her at the right time, she might be able to reach out to somebody, but it wasn't a systemic part of the office. It was sort of like, well, hopefully she'll get to it. And now we've changed from that to an actual dedicated staff person.
That's awesome. Prosecuting cases in a timely manner. The definition of that has probably changed a bit over the last 10 years. What does that mean to you, both on the personal level and then also on the legal level in terms of what the state mandates?
So the job is governed by a clock. From the moment a charge is filed, a clock starts ticking, and there are certain milestones within which you have to be ready to present the case to trial. Doesn't mean you have to have the trial scheduled within that time, but you have to be ready for it. So we always have that. That's been consistent. It hasn't changed. It's been the same for decades. But then there are times when you're working through a case and time is actually on your side to get to a resolution. For example, we might have a case involving, let's say a criminal mischief. Somebody has damaged somebody else's property, and it's a felony level offense. So it's expensive. There's a lot of money involved, thousands of dollars. The individual's working, but it's a minimum wage job. So then as you're resolving the case, you think, okay, we could put him into jail or prison, and this person probably won't ever see any of that money because they get paid a nickel a day, so you're going to probably be 6 feet under before you see your restitution. Or we can maybe place him on probation where he's supervised, have him continue his job, and make monthly payments toward the restitution so the person's guaranteed to do that. Or we can allow him some time to come up with a big chunk as a deposit. So let's say we'll adjourn the case for 3 months, and in that 3 months you come up with $3,000, and then we can move forward with the case, have you plea, and then make payments along the way. There are some times where people move. They move out of state. They want to put it behind them. And so getting them to attend takes a little bit more time. So we like to have a little bit more time to get them to come to the courtroom. So I'd have to say that it's a fluid concept, that timeliness, because sometimes you could do it very quick. Judge Porsche is a taskmaster. He does not let cases linger for very long. You have to report to him on progress that's being made, or the matter gets set for trial, and you better be ready for trial. So in that sense, he kind of keeps things moving along. But as long as progress is being made, he also will let the case adjourn for a while to help the parties negotiate maybe a little bit more, seeking a resolution or something like that. So again, it's a fluid concept, but I feel like we make effective use of the time. We've never really just let a case languish for no reason. We move along.
What's the biggest technical challenge that the DA's office faces at this point?
Discovery reform. The new laws related to discovery.
Could you explain that a little bit, just in terms of what, functionally, what that means?
So in the olden days, when I first started, you had to provide defense counsel with the evidence that you have in the case. Whatever you're going to present, you had to give that to defense counsel. And that's simplified. There's some additional things that you have to provide that maybe aren't evidence, but the defense is entitled to. But there wasn't a very strict timeline within which to do that. As long as you did it before trial, you were golden. Now, our practice has always been in Seneca County that we had an open file. So we would usually share that information as soon as we got it. We never really tried to withhold information or spring it on a defense attorney. But, the downstate legislators thought that was a inherent problem in every single office, that prosecutors are, sitting back on stacks of information, waiting for this moment to surprise the defense attorney. And that may have happened places, but it was just not an issue here. So they enacted the new bail statute, and it requires that we turn all this information over within 2 weeks of charging the person. There's some exceptions to that, and there's some refinements to it, but essentially that's the rule. Now you can imagine on a traffic ticket, for example, although the statute doesn't necessarily apply to routine traffic tickets, but let's say a simple case, let's say a petit larceny. You get a statement from the victim. Yep, that's my property. Yes, that guy stole it. You have a value for the property. You pretty much have everything you need. You turn that over. But then you talk about, an assault case or a murder case or a complicated DWI where you have lab information and testing and statements from all over the place, and you have to acquire these. Maybe people are from other states and you have to get statements from them. It becomes a little bit more difficult. So During that time, when the bail reform or the discovery reform was passed, we implemented procedures in my office to digitize the information so we could share it a little bit quicker. So law enforcement now will upload everything into their system. We have access to that system, and we're able to then turn it around, and then we send it electronically to defense attorneys so we can meet that standard. But as you can imagine, I mean, you're in a tech business. Videos come in tons of different formats, and some of them are proprietary depending on the recorder that's used. Audio recordings are in different formats. And so all of a sudden, my secretaries who were, answering the door, answering telephones, typing up motions and doing that stuff are now our tech experts who are having to figure out, okay, what's a JPEG? What's a TIFF? How do I get this loaded into the system? Why won't it play? And so that's probably our biggest technical challenge.
You say 2 weeks. Now, I think a lot of people are going to think of two different scenarios. Correct me if I'm wrong. The grand jury scenario, which I would assume is a lot simpler, versus the arrested at a random day on a random time, and then a 2-week clock starts. Does the 2-week clock literally start when the arrest happens, or is there like wiggle room there before?
It's from the date of arraignment. So as soon as the person appears and they're told, these are the charges against you, and you have a right to counsel, as soon as that happens, then that clock starts ticking, and within 2 weeks of that. Now, there are ways where you can extend that a little bit of time. The courts, since passing that law, have said, well, state lab reports, we know that that's unrealistic. So if you're doing a lab report, we'll give you a little bit of extra time for that and stuff like that. But for the most part, it's from the point of arraignment.
Bail reform. How much of an issue is that from a technical logistical standpoint for you guys, or is that something that doesn't really have too much of an impact on how you do your jobs on a daily basis?
In the sense that it's kind of frustrating where you have these defendants who maybe are repeat offenders, and you go through this process, you make an application for monetary bail, and the court says, no, I'm not going to grant that. We're going to release them again. And it's a frustration. But again, when you talk about some of the laws that Albany passes, as a Seneca County resident, you need to realize that the issues that sometimes those laws are designed to correct are not issues that are present in a small rural community like ours. As long as I've been a prosecutor, we never targeted people by race to incarcerate them on a charge when they've been arrested. We would never really hold somebody in jail for unending periods of time, causing them to lose their job before they've actually faced trial on a charge. So the notion that people would be arrested and locked away for a long period of time didn't happen here. So when they came up with the solution, it was like a solution for a problem that we don't have. Now, what we did do is occasionally when a couple is fighting and there's a domestic incident, it was nice to be able to let the guy cool off overnight in the jail so that tempers can go down and maybe more sensibility would be back. Or a person, if you stop them with a DWI, they might be able to sober up so you weren't releasing an intoxicated person back into the community. It was a useful tool sometimes for just a temporary hold with a purpose. And that's gone now. We don't have that. So in fact, a person who maybe gets in a very violent fight with somebody in their home appears at cap court, they're released back into the community. Fortunately, we could get an order of protection to keep them away, but as some people say, an order of protection is just a piece of paper and things could go wrong. The intoxicated person, again, the same thing. They're given an appearance ticket. Hopefully a law enforcement officer can find a family member or a friend to come and get them, but sometimes that doesn't happen. So it kind of makes that aspect of the job pretty difficult.
Number one thing you would change at the state level if you could?
I think a bigger voice for rural counties, because most of my rural brethren, when we talk about these laws, we shake our heads because they weren't issues for us. And I think if we could have stronger representation from upstate, rather than the problems of downstate being impugned to all of us. The laws would make a lot more sense. We're fortunate, the District Attorneys Association is united. We all are members of the association. So we have a legislative committee which updates us regularly on what's going through Albany and what could impact us. We are very strong advocates for our position. So we're constantly sending our opinions to Albany legislators and the governor's office. But at the same time, we don't have the numbers. We're not the strong population center. So who are you going to cater to? Yeah. And that seems to be the problem.
Last question. What's your pitch to voters as we head towards Election Day here?
I can't stress this enough. Please, whoever's listening, get the facts. Look at the facts. Compare our records, compare our experiences, and make a decision that makes sense based on that data and not a single letter that comes after the name of a candidate. Because I could tell you that in the 20 years that I've been with the District Attorney's Office, I was hired by a Republican District Attorney. I was promoted by a Republican District Attorney. I hired probably 90% of my staff and their Republican staff members, and I would only know that because it might come up in a casual conversation at a bar some night when we're out socializing. Never comes up in my day-to-day business as a district attorney. Politics has no place in the office. It shouldn't have a place in the office. And so if you're only going to base your vote on that, you're going to be losing out as a citizen of Seneca County. But if you compare our records and compare our experience, which I hope you do, I think it'll lead you to one choice. And that's my pitch.
Mark, thanks for the time today.
Thank you, Josh.
That'll do it for this edition of FLX Today. If you'd like to hear more conversations like this one, check out the show on your favorite podcast platform or subscribe to the FingerLakes1.com YouTube channel. Have a great day, and we will see you next time.